Well, let's start here. Last week, former South African President Jacob Zuma's military doctors handed in a confidential medical report about his fitness to stand trial for arms deal-related corruption. Former President Jacob Zuma has reportedly refused to be examined by National Prosecuting Authority-appointed doctors. Now, for the latest on this, we are joined by Karyn Maughan, who's, of course, a legal journalist. Well, I believe that Karyn's not here with us now, but we will definitely touch base with her in a moment. But let's get on to this now. Gauteng Premier David Makhura says the economic cost of last month's unrest in the province now stands at 5 billion rand, with 18,000 jobs lost. Makhura was responding to questions during a virtual sitting of the Gauteng legislature. 80 out of 500 shopping malls in Gauteng were looted and vandalized during the unrest. Small businesses, including spaza shops, were also attacked. All right, let's go back to our top story now. We're joined by legal journalist Karyn Maughan. Karyn, thank you so much for your time this afternoon. Now, on the 10th of August, if I remember correctly, lawyers came to an agreement at the Pietermaritzburg High Court that the state may grant a medical practitioner of its choice to examine the former president to assess his ability to stand trial. This is now even before the military doctors handed in this latest medical report. What does this latest development now mean for the case where former President Jacob Zuma, through his foundation, is saying that he doesn't need to be re-examined?
Well, essentially, the Jacob Zuma's foundation has taken the position that, that order stated that the doctor could give evidence if it was necessary. Now, this is the state-appointed doctor, and they have taken this to mean that the state needs to show that it's necessary for a doctor appointed by it to actually examine Jacob Zuma. Now, as we understand, that is not the understanding that the NPA has. And so it's going to end up being a situation where Judge Piet Koen, I suspect, will be asked to intervene and make a determination. But if the former president is as adamant as his foundation has suggested in its interview with News 24, we may well see a scenario where there may be a possible legal application to prevent him from being examined by the state. We know the NPA during that argument on the 10th of August, making it very clear that it was not satisfied with the initial information that was put out by the former president's military doctors about him requiring potentially 6 months of quick care because of certain emergency procedures he had to undergo, and saying that he potentially, if he didn't undergo these procedures, had a potential risk to his life. They said that they, were not fully happy with that they wanted to see a substantive report on behalf of the state in regards to that. And, we now have a scenario where the secondary order that they got, which was in relation to their own doctor being able to examine Zuma, now appears to be off the table. So I think it's very apparent, Unati, that the judge is going to have to intervene.
Exactly, Karyn. I mean, what for me is surprising, and I do understand, as South Africans do too, that every individual has a right to be examined or not, and medical information is of sensitive nature. We all know this, but the understanding in front of Judge Koen was that Jacob Zuma's lawyers had agreed, essentially, that the state could get its lawyers. And that those lawyers, if they wanted, the state could get, its medical doctors to examine the former president. And if it needs be, that medical practitioner would then also be called in to testify. So now it seems that this is a delaying tactic, or are we misrepresenting what the foundation is saying?
Well, the foundation is adamant and has been adamant that the former president is determined to face this trial, that he wants to bring a special plea in which he argues that the entire National Prosecuting Authority is simply too biased and lacks independence. It should not be able to prosecute him, lacks the title to prosecute him, and he should therefore be acquitted. Now, they've been adamant that he wants that process to play out. He wants to call witnesses from the NPA and is determined to see that through. They have also, he and the foundation have made it clear that they don't believe he should stand trial, that the entire process against him is intrinsically biased. So even when this case gets underway, eventually when it does, there's no sense that it's going to start straight away with the evidence against him and that the trial will be proceeded with. That special plea will first have to happen. In the interim, though, we know that there has been a suggestion that he intends to bring a prolonged postponement application. If the indications are from the military, authorities are correct, that would be for up to 6 months. And we now, that postponement application would need potentially to be brought on the 9th of September and will probably be in camera and not open to the public. But in the interim, now, as part of that process, the examination by the former president by a doctor appointed by the NPA obviously still needs to happen for that evidence from the NPA to be led. Because there's certainly no indication that they're simply going to accept the testimony of the military doctor. And now we're looking at potential litigation linked to that. So it's a potential litigation linked to a postponement, linked to a special plea that is ultimately about the former president being acquitted before he stands trial. All of which I think will give most of us pause to think that this corruption case is never going to get underway.
Absolutely. I mean, I was going to say, what are then the implications for the 9th of September, as you rightfully say, when the lawyers are back in court arguing for that longer postponement, with regards to this medical report. And I throw that question back to you. Will we ever see the light of day of this court of this case making it into court?
Unathi, one of the profound difficulties of the Zuma matter is that this trial should have happened in 2003, when the former president should have been charged with his then financial advisor, Shabir Sheikh, and the case should have been put to him then. We now have a scenario, all these years later, 18 years later, where you are trying to put a 79-year-old man on trial in circumstances where he faces 25 years in jail. And as we've seen in relation to his imprisonment for contempt of the Constitutional Court, it's very likely that even if he is imprisoned, he will be hospitalized almost immediately. So, this entire scenario is a manifestation of the difficulties of delaying too long in a process that should have happened a very long time ago. And unfortunately, I think that there are going to be real question marks as to whether this trial is ever going to get underway in these circumstances.
Now, Karyn, we know that the former president is currently serving 15 months in jail for defying the Concourse ruling, that he appear at state capture. When can we expect the court to rule, on his application for a rescission of that particular judgment?
Well, we know, Unathi, recently the Constitutional Court issuing directions asking for the parties involved in the case to provide submissions on whether or not international law and certain UN conventions needed to be taken into consideration by the Constitutional Court in reaching its decision. It's very obvious that the court is quite firmly divided on the issue of Jacob Zuma's imprisonment. We saw a very strong dissenting judgment from two of the justices, Liana Turan and Chris Jafta, in which they essentially accused the highest court, the Constitutional Apex Court, of acting unconstitutionally. So it's very apparent that there is going to be a split decision here. But, after asking for those submissions, all the parties supplying those submissions, very detailed about international law and its implications for this case, We don't have a sense of when the apex court is going to rule. Remember, it took over 3 months to rule on the initial contempt case. And I think the indications, the length of time that it is taking probably indicates that we're going to see another very firm split. But, you know, if they were going to release the former president because of coming to the determination that they had acted unconstitutionally, I suspect they would have acted or made a decision far sooner than they now have. And it's already apparent that, you know, the former president will remain in hospital for the duration of his sentence. He becomes eligible for parole in another, you know, just over 2 months. So that entire question around imprisonment now almost seems in many respects to be somewhat academic.
Absolutely. Karyn, just before I let you go, just as we wrap up this interview, now heading up to the 9th of September, you know, you've spoken to the NPA asking them for their, you know, comment around this latest matter where former President Jacob Zuma's lawyers are basically saying that they will not permit the NPA's doctors to examine him. What did they have to say?
Well, the National Prosecuting Authority has been immensely cagey about commenting on this matter because I think there's a huge amount of concern around the confidentiality of the former president's medical information. They have simply said that they were not going to comment, and they have said that all the issues around this matter will be resolved on the 9th of September. But Onati, at this point, we don't even know if that court hearing will actually be open to the public. So we have no real sense of what the progress will be, and if indeed the public will gain further insight into this process from being participant or allowed to observe the court hearing, or will simply have to rely on either the NPA or the Jacob Zuma Foundation for further information as to what happened.
Fantastic. Karyn Maughan, thank you so much for your time this afternoon. Really do appreciate it.